what I would do if you're doing any active defense work in DWI, take your lesson plan today, be familiar with everything, and take it with you to court. Maybe have a little spiral notebook you keep it on, because these things have the force and effect of law, and you can use them to your advantage in in advocacy when the appropriate issue comes up. The stuff is not always going to be in the case law. It's certainly not statutory, but again, it has the force and effect of law, and it can be extremely effective advocacy, especially when you whip it out and show it to the judge, say, no, judge, you got to be doing X, Y, Z, ABC, whatever it says in this directive. Do you agree with that, John?
I do. And we have a very unusual state constitution, how it sets up the authority of the courts versus the legislature. Our constitution delegates probably more power to our courts than any other state, because courts, rules, directives, when it comes to procedural matters, those will trump what the legislature says about procedure. When it comes to substantive law, the legislature, of course, has the final word. So yes, these directives are very important to keep in mind. Even the 60-day rule, as ridiculous as that is, it's still on the books.
I think you're referring to this old Winbury versus Salisbury decision about, you got a court rule and you got a statute which takes precedence, okay? And Supreme Court really established that position very, very early on in the history of our 1947 Constitution in that case. In any event, John Menzel, any final words of advice for our viewers today about defending DWI cases these days?
Listen, assess the sentencing exposure. If there's very little difference between what they get after a plea versus after what they get at a trial, go to trial. God, how many times do we get that kind of practice? A lot of us get it more than others, but you really have very little downside risk going to trial in most DWI cases. Yeah, go forth, break a leg.
Your client's a first offender, 0.14. What's the downside?
4 months of interlock.
Yeah. So as long as your client's happy with it, there's no reason. And you know what? You develop a reputation for this. We see these ads on TV all the time for Morgan & Morgan. Have you seen them, Johnny? It's a Florida firm throughout the whole country. They're in Pennsylvania. I don't think they're in New Jersey yet, but that's just a matter of time. But they have a policy at their firm. Every single attorney in that firm, without exception, is required to try 3 personal injury cases a year, even if they're utterly without merit. 3 a year. And there's 2 reasons for that. Number 1, to keep them sharp on their trial skills, but also number 2, to send a message to these insurance companies that we're not afraid to try these cases, and we will try them. We'll try them to verdict, even if it's an adverse determination, even if we get no cause. Okay. And I think sometimes as an advocate, you have to do that. It doesn't hurt you to stand up there, especially if it's not going to hurt your client. If they've offered you nothing in terms of resolving the case by way of a plea, what's the downside to trying it? You send a message to everybody, let them know you're not afraid to do that. It may benefit down the line.
The number 1 ethical rule, Bob, you got to charge enough of a legal fee so you don't feel guilty about trying.
I haven't had that problem. My fees aren't high enough.